This is the Mueller Report audio, presented by Government Unfiltered. I'm Dan Williams. This version of the Mueller Report contains updates released by the Department of Justice in June and November 2020, following lawsuits by BuzzFeed News and the Electronic Privacy Information Center. Due to these new releases and through the support of your donations, I'm re-releasing the Mueller Report audio to replace the previous versions and compiling the subsections into their larger sections. The previous episodes will be archived and available at MuellerReportAudio.com. To keep these episodes commercial-free and free for everyone to access, this podcast operates on the value-for-value model. I produce the audio, and you decide what it's worth. You can donate at MuellerReportAudio.com, or, as I continue to read public documents and make them available here in audio format, you can support with a recurring monthly donation at patreon.com/TimberlaneMedia. Section 5. Prosecution and Declination Decisions. The appointment order authorized the Special Counsel's Office to prosecute federal crimes arising from its investigation of the matters assigned to it. In deciding whether to exercise this prosecutorial authority, the office has been guided by the principles of federal prosecution set forth in the Justice, formerly U.S. Attorney's, Manual. In particular, the office has evaluated whether the conduct of the individuals considered for prosecution constituted a federal offense and whether admissible evidence would probably be sufficient to obtain and sustain a conviction for such an offense. Where the answer to those questions was yes, the office further considered whether the prosecution would serve a substantial federal interest, the individuals were subject to effective prosecution in another jurisdiction, and there existed an adequate non-criminal alternative to prosecution. As explained below, those considerations led the office to seek charges against two sets of Russian nationals for their role in perpetrating the Active Measures social media campaign and computer-intrusion operations. The office concluded, however, that it did not have sufficient evidence to obtain or sustain a conviction of WikiLeaks or one U.S. national connected to the campaign, Roger Stone, for participating in the computer-intrusion conspiracy. The office similarly determined that the contacts between campaign officials and Russia-linked individuals either did not involve the commission of a federal crime or, in the case of campaign finance offenses, that our evidence was not sufficient to obtain and sustain a criminal conviction. At the same time, the office concluded that the principles of federal prosecution supported charging certain individuals connected to the campaign with making false statements or otherwise obstructing this investigation or parallel congressional investigations. Section 5A. Russian Active Measures social media campaign. On February 16, 2018, a federal grand jury in the District of Columbia returned an indictment charging 13 Russian nationals and 3 Russian entities, including the Internet Research Agency, IRA, and Concord Management and Consulting LLC, Concord, with violating U.S. criminal laws in order to interfere with U.S. elections and political processes. The indictment charges all of the defendants with conspiracy to defraud the United States, count 1, 3 defendants with conspiracy to commit wire fraud and bank fraud, count 2, and 5 defendants with aggravated identity theft, counts 3 through 8. Concord, which is one of the entities charged in the count 1 conspiracy, entered an appearance through U.S. counsel and moved to dismiss the charge on multiple grounds. In orders and memorandum opinions issued on August 13 and November 15, 2018, the District Court denied Concord's motions to dismiss. As of this writing, the prosecution of Concord remains ongoing before the U.S. District Court for the District of Columbia. The other defendants remain at large. Although members of the IRA had contact with individuals affiliated with the Trump campaign, the indictment does not charge any Trump campaign official or any other U.S. person with participating in the conspiracy. That is because the investigation did not identify evidence that any U.S. person who coordinated or communicated with the IRA knew that he or she was speaking with Russian nationals engaged in the criminal conspiracy. The office therefore determined that such persons did not have the knowledge or criminal purpose required to charge them in the conspiracy to defraud the United States, count 1, or in the separate count alleging a wire and bank fraud conspiracy involving the IRA and 2 individual Russian nationals, count 2. The office did, however, charge 1 U.S. national for his role in supplying false or stolen bank account numbers that allowed the IRA conspirators to access U.S. online payment systems by circumventing those systems' security features. On February 12, 2018, Richard Pinedo pleaded guilty pursuant to a single-count information to identity fraud in violation of 18 U.S. Code Section 1028A7 and B1D. The investigation did not establish that Pinedo was aware of the identity of the IRA members who purchased bank account numbers from him. Pinedo's sales of account numbers enabled the IRA members to anonymously access a financial network through which they transacted with U.S. persons and companies. On October 10, 2018, Pinedo was sentenced to 6 months of imprisonment, to be followed by 6 months of home confinement, and was ordered to complete 100 hours of community service. Section 5B. Russian Hacking and Dumping Operations. 1. Section 1030. Computer-Intrusion Conspiracy. A. Background. On July 13, 2018, a federal grand jury in the District of Columbia returned an indictment charging Russian military intelligence officers from the GRU with conspiring to hack into various U.S. computers used by the Clinton campaign, DNC, DCCC, and other U.S. persons in violation of 18 U.S. Code, Sections 1030 and 371. Count 1. Committing identity theft and conspiring to commit money laundering in furtherance of that hacking conspiracy, in violation of 18 U.S. Code, Sections 1028A and 1956H, Counts 2 through 10. And a separate conspiracy to hack into the computers of U.S. persons and entities responsible for the administration of the 2016 U.S. election, in violation of 18 U.S. Code, Sections 1030 and 371, Count 11. As of this writing, all 12 defendants remain at large. The Natik-Show indictment alleges that the defendants conspired with one another and with others to hack into the computers of U.S. persons and entities involved in the 2016 U.S. presidential election, steal documents from those computers, and stage releases of the stolen documents to interfere in the election. The indictment also describes how, in staging the releases, the defendants used the Guccifer 2.0 persona to disseminate documents through WikiLeaks. On July 22, 2016, WikiLeaks released over 20,000 emails and other documents that the hacking conspirators had stolen from the DNC. In addition, on October 7, 2016, WikiLeaks began releasing emails that some conspirators had stolen from Clinton campaign chairman John Podesta after a successful spearphishing operation. One witness told the office at one point that the initial release of Podesta emails on October 7 may have come at the behest of, or in coordination with, Roger Stone, an associate of candidate Trump. As explained in Volume 1, Section 3D1D, Supra, phone records show that Stone called Jerome Corsi on October 7, after Stone received a call from the Washington Post. The Washington Post broke a story later that day about a video recording of Trump speaking about women in graphic terms. According to some of Corsi's statements to the office, short redaction citing grand jury, Stone said that he had learned about the imminent release of that tape recording, and it was expected to generate significant negative media attention for the campaign. Corsi told investigators that Stone may have believed from their prior dealings that Corsi had connections to Julian Assange, WikiLeaks founder, and that Stone therefore asked Corsi to tell Assange to start releasing the Podesta emails immediately to shift the news cycle away from the damaging Trump recording. Although Corsi denies that he actually had access to Assange, he told the office at one point that he tried to bring the request to Assange's attention via public Twitter posts and by asking other contacts to get in touch with Assange. The investigation did not establish that Corsi actually took those steps, but WikiLeaks did release the first batch of Podesta emails later on the afternoon of October 7, within an hour of the publication of the Washington Post's story on the Trump tape. B. Charging decision as to WikiLeaks, Julian Assange, and Roger Stone. Given WikiLeaks' role in disseminating the hacked materials, and the existence of some evidence that Stone played a role in coordinating the October 7 release of the Podesta materials, this office considered whether to charge WikiLeaks, Assange, or Stone as conspirators in the computer-intrusion conspiracy under Sections 1030 and 371. The theory of prosecution would be that these actors were liable as late joiners in an already existing conspiracy. In particular, although it did not participate in the hacking itself, WikiLeaks would be liable for ensuring a market for and maximizing the value of the stolen materials, much as someone who holds himself out as a fence may be found to have joined a conspiracy to traffic in stolen goods, and an individual who launders drug money can be a member of a drug trafficking conspiracy when such laundering activities are integral to the success of the overall trafficking venture. Stone might similarly be liable under these cases if he too was integral to the computer-intrusion conspiracy's success by ensuring that the stolen materials had their maximum impact upon dissemination. The office determined, however, that it did not have admissible evidence that was probably sufficient to obtain and sustain a Section 1030 conspiracy conviction of WikiLeaks, Assange, or Stone. The foregoing theory of conspiracy liability depends on proof of an agreement. It would also require evidence of knowledge on the part of the putative conspirator that the criminal objective of the conspiracy has not yet been completed. A fence, who had no advance knowledge of the plan to steal the goods he disposes of, for example, is generally not liable for conspiring to steal those goods. Here, a late joiner theory would require that the conspirator knew that the computer intrusions that comprise the Section 1030 violation were ongoing or expected to continue at the time that he or she joined the conspiracy. With respect to WikiLeaks and Assange, this office determined the admissible evidence to be insufficient on both the agreement and knowledge prongs. As to agreement, many of the communications between the GRU officers and WikiLeaks-affiliated actors occurred via encrypted chats. Although a conspiracy is often inferred from the circumstances, the lack of visibility into the contents of these communications would hinder the office's ability to prove that WikiLeaks was aware of and intended to join the criminal venture comprised of the GRU hackers. Similar problems of proof existed as to knowledge. While the investigation developed evidence that the GRU's hacking efforts in fact were continuing at least at the time of the July 2016 WikiLeaks dissemination, the office did not develop sufficient admissible evidence that WikiLeaks knew of, or even was willfully blind to, that fact. And absent sufficient evidence of such knowledge, the government could not prove that WikiLeaks or Assange joined an ongoing hacking conspiracy intending to further or facilitate additional computer intrusions. The office determined that it could not pursue a Section 1030 conspiracy charge against Stone for some of the same legal reasons. The most fundamental hurdles, though, are factual ones. As explained in Volume 1, Section 3D1 Supra, Corsi's accounts of his interactions with Stone on October 7, 2016, are not fully consistent or corroborated. Even if they were, neither Corsi's testimony nor other evidence currently available to the office is sufficient to prove beyond a reasonable doubt that Stone knew or believed that the computer intrusions were ongoing at the time he ostensibly encouraged or coordinated the publication of the Podesta emails. Stone's actions would thus be consistent with, among other things, a belief that he was aiding in the dissemination of the fruits of an already completed hacking operation perpetrated by a third party, which would be a level of knowledge insufficient to establish conspiracy liability. The office's determination that it could not charge WikiLeaks or Stone as part of the Section 1030 conspiracy was also informed by the constitutional issues that such a prosecution would present. Under the Supreme Court's decision in Bartnicki v. Vopper, the First Amendment protects a party's publication of illegally intercepted communications on a matter of public concern, even when the publishing parties knew or had reason to know of the intercept's unlawful origin. Any effort by WikiLeaks to invoke Bartnicki would raise an initial question whether, as a foreign actor, WikiLeaks is entitled to claim the protections of the First Amendment. But assuming that a First Amendment defense is available to WikiLeaks, or that Stone raised one, a court could conclude that Bartnicki's holding applies equally to actors such as WikiLeaks and Stone on the ground that they published or caused the publication of previously hacked materials without participating directly in the initial illegality of the computer intrusions. The government might be able to distinguish Bartnicki on the ground that, under the late joiner principles of conspiracy law described above, WikiLeaks and Stone were complicit in the computer intrusions. That contention would succeed only if qualifying as a conspirator under late joiner principles establishes sufficient participation under Bartnicki, a question that the decision itself does not resolve. Regardless, success would also depend upon evidence of WikiLeaks's and Stone's knowledge of ongoing or contemplated future computer intrusions. the proof that is currently lacking. The absence of evidence as to knowledge, in short, would both hinder the government's ability to prove conspiracy liability and also potentially provide a First Amendment defense. Therefore, the office did not seek charges against WikiLeaks, Assange, or Stone for participating in the computer-intrusion conspiracy alleged in Count 1 of the Netixo indictment. 2. Potential Section 1030 violation by short redaction citing personal privacy. The office also considered whether short redaction citing personal privacy intentionally accessed a protected computer without authorization, in violation of 18 U.S. Code, Section 1030A2C and C2A. The conduct at issue was 2 lines redacted, citing personal privacy. The facts known to the office likely suffice to establish each element of a misdemeanor violation of Section 1030A2C. 1 line redacted, citing personal privacy. That evidence would support a conclusion, short redaction citing personal privacy, accessed a computer without authorization. 1.5 lines redacted, citing personal privacy. That same course of conduct and short redaction citing personal privacy also suggested that short redaction citing personal privacy acted intentionally. In addition, the computer, short redaction citing personal privacy, likely qualifies as a protected one under the statute, which reaches effectively all computers with Internet access. And about half a line redacted, citing personal privacy, likely suffice to demonstrate short redaction citing personal privacy obtained information from the computer, since the word obtain in this provision includes mere observation of the data, even without an attempt to copy or download it. Applying the principles of federal prosecution, however, the office determined that prosecution of this potential violation was not warranted. Those principles instruct prosecutors to consider, among other things, the nature and seriousness of the offense, the person's culpability in connection with the offense, and the probable sentence to be imposed if the prosecution is successful. 3.5 lines redacted, citing personal privacy. That fact, among others, would make it difficult to prove that short redaction citing personal privacy acted to further any crime or tort, or short redaction citing personal privacy obtained information valued at more than $5,000, which are the kind of circumstances that can trigger felony punishment under the statute. 1 line redacted, citing personal privacy. The absence of evidence that short redaction citing personal privacy or obtained valuable information, the technical nature of the violation, and the minimal punishment that a misdemeanor conviction could be expected to carry in these circumstances, the office decided against pursuing charges. Section 5C. Russian Government Outreach and Contacts. As explained in Section 4 above, the office's investigation uncovered evidence of numerous links, i.e. contacts, between Trump campaign officials and individuals having or claiming to have ties to the Russian government. The office evaluated the contacts under several sets of federal laws, including conspiracy laws and statutes governing foreign agents who operate in the United States. After considering the available evidence, the office did not pursue charges under these statutes against any of the individuals discussed in Section 4 above, with the exception of FARA charges against Paul Manafort and Richard Gates, based on their activities on behalf of Ukraine. One of the interactions between the Trump campaign and Russian-affiliated individuals, the June 9, 2016 meeting between high-ranking campaign officials and Russians promising derogatory information on Hillary Clinton, implicates an additional body of law, campaign finance statutes. Schemes involving the solicitation or receipt of assistance from foreign sources raise difficult statutory and constitutional questions. As explained below, the office evaluated those questions in connection with the June 9 meeting and WikiLeaks' release of stolen materials. The office ultimately concluded that even if the principal legal questions were resolved favorably to the government, a prosecution would encounter difficulties proving that campaign officials or individuals connected to the campaign willfully violated the law. Finally, although the evidence of contacts between campaign officials and Russia-affiliated individuals may not have been sufficient to establish or sustain criminal charges, several U.S. persons connected to the campaign made false statements about those contacts and took other steps to obstruct the office's investigation and those of Congress. This office has therefore charged some of those individuals with making false statements and obstructing justice. 1. Potential coordination, conspiracy, and collusion. As an initial matter, this office evaluated potentially criminal conduct that involved the collective action of multiple individuals, not under the rubric of collusion, but through the lens of conspiracy law. In doing so, the office recognized that the word collude appears in the Acting Attorney General's August 2, 2017 memorandum. It has frequently been invoked in public reporting, and it is sometimes referenced in antitrust law. But collusion is not a specific offense or theory of liability found in the U.S. Code, nor is it a term of art in federal criminal law. To the contrary, even as defined in legal dictionaries, collusion is largely synonymous with conspiracy, as that crime is set forth in the General Federal Conspiracy Statute, 18 U.S. Code, Section 371. For that reason, this office's focus in resolving the question of joint criminal liability was on conspiracy as defined in federal law, not the commonly discussed term collusion. The office considered, in particular, whether contacts between Trump campaign officials and Russia-linked individuals could trigger liability for the crime of conspiracy, either under statutes that have their own conspiracy language or under the General Conspiracy Statute. The investigation did not establish that the contacts described in Volume 1, Section 4 Supra amounted to an agreement to commit any substantive violation of federal criminal law, including foreign influence and campaign finance laws, both of which are discussed further below. The office therefore did not charge any individual associated with the Trump campaign with conspiracy to commit a federal offense arising from Russia contacts, either under a specific statute or under Section 371's Offenses Clause. The office also did not charge any campaign official or associate with a conspiracy under Section 371's Defraud Clause. That clause criminalizes participating in an agreement to obstruct a lawful function of the U.S. government or its agencies through deceitful or dishonest means. The investigation did not establish any agreement among campaign officials or between such officials and Russia-linked individuals to interfere with or obstruct a lawful function of a government agency during the campaign or transition period. And as discussed in Volume 1, Section 5A Supra, the investigation did not identify evidence that any campaign official or associate knowingly and intentionally participated in the conspiracy to defraud that the office charged, namely the active measures conspiracy described in Volume 1, Section 2 Supra. Accordingly, the office did not charge any campaign associate or other U.S. person with conspiracy to defraud the United States based on the Russia-related contacts described in Section 4 above. 2. Potential coordination, Foreign Agent Statutes, FARA, and 18 U.S. Code, Section 951. The office next assessed the potential liability of campaign-affiliated individuals under federal statutes regulating actions on behalf of or work done for a foreign government. A. Governing law. Under 18 U.S. Code, Section 951, it is generally illegal to act in the United States as an agent of a foreign government without providing notice to the Attorney General. Although the defendant must act on behalf of a foreign government, as opposed to other kinds of foreign entities, the acts need not involve espionage. Rather, acts of any type suffice for liability. An agent of a foreign government is an individual who agrees to operate in the United States, subject to the direction or control of a foreign government or official. The crime defined by Section 951 is complete upon knowingly acting in the United States as an unregistered foreign government agent. The statute does not require willfulness, and knowledge of the notification requirement is not an element of the offense. The Foreign Agents Registration Act, FARA, generally makes it illegal to act as an agent of a foreign principal by engaging in certain, largely political, activities in the United States without registering with the Attorney General. The triggering agency relationship must be with a foreign principal or a person any of whose activities are directly or indirectly supervised, directed, controlled, financed, or subsidized in whole or in major part by a foreign principal. That includes a foreign government or political party and various foreign individuals and entities. A covered relationship exists if a person acts as an agent, representative, employee, or servant, or in any other capacity at the order, request, or under the foreign principal's direction or control. It is sufficient if the person agrees, consents, assumes, or purports to act as, or who is or holds himself out to be, whether or not pursuant to contractual relationship, an agent of a foreign principal. The triggering activity is that the agent directly or through any other person in the United States, 1. Engages in political activities for or in the interests of the foreign principal, which includes attempts to influence federal officials or the public. 2. acts as public relations counsel, publicity agent, information service employee, or political consultant for or in the interests of such foreign principal. 3. Solicits, collects, disperses, or dispenses contributions, loans, money, or other things of value for or in the interest of such foreign principal. Or 4. Represents the interests of such foreign principal before any federal agency or official. It is a crime to engage in a willful violation of any provision of the Act or any regulation thereunder. It is also a crime willfully to make false statements or omissions of material facts in FARA registration statements or supplements. Most violations have a maximum penalty of 5 years of imprisonment and a $10,000 fine. B. Application. The investigation uncovered extensive evidence that Paul Manafort's and Richard Gates' pre-campaign work for the government of Ukraine violated FARA. Manafort and Gates were charged for that conduct and admitted to it when they pleaded guilty to superseding criminal informations in the District of Columbia prosecution. The evidence underlying those charges is not addressed in this report because it was discussed in public court documents and in a separate prosecution memorandum submitted to the acting attorney general before the original indictment in that case. In addition, the investigation produced evidence of FARA violations involving Michael Flynn. Those potential violations, however, concerned a country other than Russia, i.e. Turkey, and were resolved when Flynn admitted to the underlying facts in the statement of offense that accompanied his guilty plea to a false statements charge. The investigation did not, however, yield evidence sufficient to sustain any charge that any individual affiliated with the Trump campaign acted as an agent of a foreign principal within the meaning of FARA or, in terms of Section 951, subject to the direction or control of the government of Russia or any official thereof. In particular, the office did not find evidence likely to prove beyond a reasonable doubt that campaign officials such as Paul Manafort, George Papadopoulos, and Carter Page acted as agents of the Russian government or at its direction, control, or request during the relevant time period. Likewise, short redaction citing personal privacy, the evidence did not establish that short redaction citing personal privacy was acting at the direction of Russia when one-line redacted citing personal privacy. As a result, the office did not charge short redaction citing personal privacy any other Trump campaign official with violating FARA or Section 951, or attempting or conspiring to do so based on contacts with the Russian government or a Russian principal. Finally, the office investigated whether one of the above campaign advisors, George Papadopoulos, acted as an agent of, or at the direction and control of, the government of Israel. While the investigation revealed significant ties between Papadopoulos and Israel, and search warrants were obtained in part on that basis, the office ultimately determined that the evidence was not sufficient to obtain and sustain a conviction under FARA or Section 951. 3. Campaign finance. Several areas of the office's investigation involved efforts or offers by foreign nationals to provide negative information about candidate Clinton to the Trump campaign or to distribute that information to the public, to the anticipated benefit of the campaign. As explained below, the office considered whether two of those efforts in particular, the June 9, 2016 meeting at Trump Tower and WikiLeaks' dissemination of hacked emails, constituted prosecutable violations of the campaign finance laws. The office determined that the evidence was not sufficient to charge either incident as a criminal violation. A. Overview of governing law. The United States has a compelling interest in limiting the participation of foreign citizens in activities of democratic self-government and in thereby preventing foreign influence over the U.S. political process. To that end, federal campaign finance law broadly prohibits foreign nationals from making contributions, donations, expenditures, or other disbursements in connection with federal, state, or local candidate elections, and prohibits anyone from soliciting, accepting, or receiving such contributions or donations. As relevant here, foreign nationals may not make, and no one may solicit, accept, or receive from them, a contribution or donation of money or other thing of value, or an express or implied promise to make a contribution or donation in connection with a federal, state, or local election. The term contribution, which is used throughout the campaign finance law, includes any gift, subscription, loan, advance, or deposit of money or anything of value made by any person for the purpose of influencing any election for federal office. It excludes, among other things, the value of volunteer services. Foreign nationals are also barred from making an expenditure, independent expenditure, or disbursement for an electioneering communication. The term expenditure includes any purchase, payment, distribution, loan, advance, deposit, or gift of money or anything of value made by any person for the purpose of influencing any election for federal office. It excludes, among other things, news stories and nonpartisan get-out-the-vote activities. An independent expenditure is an expenditure expressly advocating the election or defeat of a clearly identified candidate, and made independently of the campaign. An electioneering communication is a broadcast communication that refers to a clearly identified candidate for federal office and is made within specified time periods and targeted at the relevant electorate. The statute defines foreign national by reference to FARA and the Immigration and Nationality Act, with minor modification. That definition yields 5, sometimes overlapping categories of foreign nationals, which include all of the individuals and entities relevant for present purposes, namely, foreign governments and political parties, individuals outside the U.S. who are not legal permanent residents, and certain non-U.S. entities located outside of the U.S. A knowing and willful violation involving an aggregate of $25,000 or more in a calendar year is a felony. A knowing and willful violation involving an aggregate of $2,000 or more in a calendar year, but less than $25,000, is a misdemeanor. B. Application to June 9 Trump Tower meeting. The office considered whether to charge Trump campaign officials with crimes in connection with the June 9 meeting described in Volume 1, Section 4A5 Supra. The office concluded that, in light of the government's substantial burden of proof on issues of intent, knowing and willful, and the difficulty of establishing the value of the offered information, criminal charges would not meet the Justice Manual standard that the admissible evidence will probably be sufficient to obtain and sustain a conviction. In brief, the key facts are that, on June 3, 2016, Robert Goldstone emailed Donald Trump Jr. to pass along from Emin and Arisa Galarov an offer from Russia's Crown Prosecutor to the Trump campaign of official documents and information that would incriminate Hillary and her dealings with Russia and would be very useful to Trump Jr.'s father. The email described this as very high-level and sensitive information that is part of Russia and its government's support to Mr. Trump, helped along by Aris and Emin. Trump Jr. responded, "If that's what you say, I love it, especially later in the summer." Trump Jr. and Emin and Galarov had follow-up conversations and, within days, scheduled a meeting with Russian representatives that was attended by Trump Jr., Manafort, and Kushner. The communications setting up the meeting and the attendance by high-level campaign representatives support an inference that the campaign anticipated receiving derogatory documents and information from official Russian sources that could assist candidate Trump's electoral prospects. This series of events could implicate the federal election law ban on contributions and donations by foreign nationals. Specifically, Goldstone passed along an offer purportedly from a Russian government official to provide official documents and information to the Trump campaign for the purposes of influencing the presidential election. Trump Jr. appears to have accepted that offer and to have arranged a meeting to receive those materials. Documentary evidence in the form of email chains supports the inference that Kushner and Manafort were aware of that purpose and attended the June 9 meeting, anticipating the receipt of helpful information to the campaign from Russian sources. The office considered whether this evidence would establish a conspiracy to violate the foreign contributions ban in violation of 18 U.S. Code Section 371, the solicitation of an illegal foreign source contribution, or the acceptance or receipt of an express or implied promise to make a foreign source contribution, both in violation of 52 U.S. Code, Section 30121 A1A and A2. There are reasonable arguments that the offered information would constitute a thing of value within the meaning of these provisions, but the office determined that the government would not be likely to obtain and sustain a conviction for 2 other reasons. First, the office did not obtain admissible evidence likely to meet the government's burden to prove beyond a reasonable doubt that these individuals acted willfully, i.e., with general knowledge of the illegality of their conduct, and second, the government would likely encounter difficulty in proving beyond a reasonable doubt that the value of the promised information exceeded the threshold for a criminal violation. 1. Thing of value element. A threshold legal question is whether providing to a campaign documents and information of the type involved here would constitute a prohibited campaign contribution. The foreign contribution ban is not limited to contributions of money. It expressly prohibits a contribution or donation of money or other thing of value. And the term contribution is defined throughout the campaign finance laws to include any gift, subscription, loan, advance, or deposit of money, or anything of value. The phrases thing of value and anything of value are broad and inclusive enough to encompass at least some forms of valuable information. Throughout the United States Code, these phrases serve as terms of art that are construed broadly. For example, the term thing of value encompasses law enforcement reports that would reveal the identity of informants, classified materials, confidential information about a competitive bid, secret grand jury information, and information about a witness's whereabouts. And in the public corruption context, thing of value is defined broadly to include the value which the defendant subjectively attaches to the items received. Federal Election Commission (FEC) regulations recognize the value to a campaign of at least some forms of information, stating that the term anything of value includes the provision of any goods or services without charge, such as membership lists and mailing lists. The FEC has concluded that the phrase includes a state-by-state list of activists. Likewise, polling data provided to a campaign constitutes a contribution, and in the specific context of the foreign contributions ban, the FEC has concluded that election materials used in previous Canadian campaigns, including flyers, advertisements, door hangers, trifolds, signs, and other printed material, constitute anything of value, even though the value of these materials may be nominal or difficult to ascertain. These authorities would support the view that candidate-related opposition research given to a campaign for the purpose of influencing an election could constitute a contribution to which the foreign source ban could apply. A campaign can be assisted not only by the provision of funds, but also by the provision of derogatory information about an opponent. Political campaigns frequently conduct and pay for opposition research. A foreign entity that engaged in such research and provided resulting information to a campaign could exert a greater effect on an election, and a greater tendency to ingratiate the donor to the candidate than a gift of money or tangible things of value. At the same time, no judicial decision has treated the voluntary provision of uncompensated opposition research or similar information as a thing of value that could amount to a contribution under campaign finance law. Such an interpretation could have implications beyond the foreign source ban and raise First Amendment questions. Those questions could be especially difficult where the information consisted simply of the recounting of historically accurate facts. It is uncertain how courts would resolve those issues. 2. Willfulness. Even assuming that the promised documents and information that would incriminate Hillary constitute a thing of value under campaign finance law, the government would encounter other challenges in seeking to obtain and sustain a conviction. Most significantly, the government has not obtained admissible evidence that is likely to establish the scienter requirement beyond a reasonable doubt. To prove that a defendant acted knowingly and willfully, the government would have to show that the defendant had general knowledge that his conduct was unlawful. This standard creates an elevated scienter element requiring, at the very least, that application of the law to the facts in question be fairly clear. When there is substantial doubt concerning whether the law applies to the facts of a particular matter, the offender is more likely to have an intent defense. On the facts here, the government would unlikely be able to prove beyond a reasonable doubt that the June 9 meeting participants had general knowledge that their conduct was unlawful. The investigation has not developed evidence that the participants in the meeting were familiar with the foreign contribution ban or the application of federal law to the relevant factual context. The government does not have strong evidence of surreptitious behavior or efforts at concealment at the time of the June 9 meeting. While the government has evidence of later efforts to prevent disclosure of the nature of the June 9 meeting that could circumstantially provide support for a showing of scienter, that concealment occurred more than a year later, involved individuals who did not attend the June 9 meeting, and may reflect an intention to avoid political consequences rather than any prior knowledge of illegality. Additionally, in light of the unresolved legal questions about whether giving documents and information of the sort offered here constitutes a campaign contribution, Trump Jr. could mount a factual defense that he did not believe his response to the offer and the June 9 meeting itself violated the law. Given his less direct involvement in arranging the June 9 meeting, Kushner could likely mount a similar defense. And while Manafort is experienced with political campaigns, the office has not developed evidence showing that he had relevant knowledge of these legal issues. 3. Difficulties in valuing promised information. The office would also encounter difficulty proving, beyond a reasonable doubt, that the value of the promised documents and information exceeds the $2,000 threshold for a criminal violation, as well as the $25,000 threshold for felony punishment. The type of evidence commonly used to establish the value of non-monetary contributions, such as pricing the contribution on a commercial market or determining the upstream acquisition cost or the cost of distribution, would likely be unavailable or ineffective in this factual setting. Although damaging opposition research is surely valuable to a campaign, it appears that the information ultimately delivered in the meeting was not valuable. And while value in a conspiracy may well be measured by what the participants expected to receive at the time of the agreement, Goldstone's description of the offered material here was quite general. His suggestion of the information's value, i.e., that it would incriminate Hillary and would be very useful to Trump Jr.'s father, was nonspecific and may have been understood as being of uncertain worth or reliability given Goldstone's lack of direct access to the original source. The uncertainty over what would be delivered could be reflected in Trump Jr.'s response. If it's what you say, I love it. Accordingly, taking into account the high burden to establish a culpable mental state in a campaign finance prosecution, and the difficulty in establishing the required valuation, the office decided not to pursue criminal campaign finance charges against Trump Jr. or other campaign officials for the events culminating in the June 9 meeting. C. Application to WikiLeaks and Roger Stone. The office also considered whether WikiLeaks and anyone connected to the Trump campaign had liability in connection with WikiLeaks' months-long releases of stolen emails and other documents, possibly with the aim of influencing the 2016 presidential election. The office explored whether WikiLeaks' actions could constitute a prohibited expenditure, which includes any purchase, payment, distribution, loan, advance, deposit, or gift of money, or anything of value, made by any person for the purpose of influencing any election for federal office, but excludes, among other things, any news story, commentary, or editorial distributed through the facilities of any broadcasting station, newspaper, magazine, or other periodical publication, unless such facilities are owned or controlled by any political party, political committee, or candidate. News stories and nonpartisan get-out-the-vote activities. The office concluded that substantial questions exist about whether the release of emails could be treated as an expenditure, whether the government could establish willfulness, and whether prosecution of this conduct would be subject to a First Amendment defense. In combination, those factors created sufficient doubt that the office could obtain and sustain a conviction based on WikiLeaks' conduct. There is also insufficient evidence at the present time to establish beyond a reasonable doubt that Roger Stone or any other persons associated with the campaign coordinated with WikiLeaks on the release of the emails, which alone would preclude prosecution of them for the WikiLeaks-related conduct, even if WikiLeaks had violated campaign finance law. Finally, and in any event, the office took into consideration several of the legal uncertainties discussed above with respect to June 9. 1. Questions over whether WikiLeaks' activities are covered by the campaign finance laws. Substantial questions exist about whether WikiLeaks' activity in posting documents is covered by the campaign finance laws. Threshold questions include whether stolen emails constitute anything of value, as used in the statute defining the term expenditure, and whether the posting of documents online qualifies as a gift or as any of the other types of transactions described in that statute: purchase, payment, distribution, loan, advance, deposit. Assuming that they do, two other hurdles would pose challenges. First, in Blumen, a three-judge court held that the ban on foreign national expenditures, in contrast to contributions or donations, is limited to expenditures to expressly advocate the election or defeat of a political candidate, i.e., express campaign speech, or its functional equivalent. That standard would require more than that the posted emails were intended to influence elections and would have that effect. Rather, they must be susceptible of no reasonable interpretation other than as an appeal to vote for or against a specific candidate. If the standard articulated in that decision governs, then it is unlikely that the distribution of emails, divorced from messaging that expressly advocates the election or defeat of a candidate, through particular magic words or the functional equivalent, would satisfy it. Second, pursuant to its authority to prescribe rules, regulations, and forms to carry out the campaign finance laws, the FEC has promulgated regulations that exclude most Internet activity from the category of expenditures. That regulation generally excludes posting, hosting, blogging, and similar internet activities where they are uncompensated. That exclusion may well cover WikiLeaks' activities. 2. Willfulness. As discussed, to establish a criminal campaign finance violation, the government must prove that the defendant acted knowingly and willfully. That standard requires proof that the defendant knew generally that his conduct was unlawful. Given the uncertainties noted above, the willfulness requirement would pose a substantial barrier to prosecution. 3. Constitutional considerations. Finally, the First Amendment could pose constraints on a prosecution. Even if WikiLeaks, as a non-citizen abroad, could not assert First Amendment rights, WikiLeaks could argue that the transmission of information into the United States that did not involve express advocacy implicates the First Amendment rights of American audiences. Assuming that no coordination with the campaign occurred, a criminal prosecution of overseas actors providing non-express advocacy information to American listeners would likely be difficult. 4. Analysis as to Roger Stone. The office also considered whether Roger Stone could be prosecuted for any direct or indirect contacts with WikiLeaks about its release of hacked emails for the purpose of influencing the presidential election, and whether any coordination between Stone and WikiLeaks would affect WikiLeaks' criminal exposure. If WikiLeaks' release of documents were conducted in coordination with Stone or others associated with the Trump campaign, the activity would arguably constitute a contribution rather than an expenditure. That characterization would potentially render Blumen's express advocacy limitation inapplicable, because Blumen had applied that interpretation only to expenditures made independent of a campaign, and would significantly alleviate the First Amendment concerns identified above, because coordinated election activity would implicate the compelling interest in preventing foreign participation in the U.S. political process and in avoiding quid pro quo corruption or its appearance. The office did not pursue that theory, however, because the investigation did not identify sufficient credible evidence that would establish that Stone coordinated with WikiLeaks or that any contacts with WikiLeaks were attributable to the campaign. While the office cannot exclude the possibility of coordination between Stone and WikiLeaks, or that additional evidence could come to light on that issue, the investigation did not obtain admissible evidence likely to meet the government's burden to prove facts establishing such coordination beyond a reasonable doubt. In any event, even if the office could establish coordination, arguments premised on a showing of coordination would not address the questions discussed above about whether electronic documents posted on the Internet are things of value covered by the campaign finance laws, nor would it address the FEC's regulation providing that uncompensated Internet activity is not a contribution, even if done in coordination with a campaign. Those reasons for questioning the applicability of the campaign finance laws to the facts at issue would similarly make it difficult to establish the general knowledge of illegality necessary to prove a willful violation. 4. False statements and obstruction of the investigation. The office determined that certain individuals associated with the campaign lied to investigators about campaign contacts with Russia and have taken other actions to interfere with the investigation. As explained below, the office therefore charged some U.S. persons connected to the campaign with false statements and obstruction offenses. A. Overview of governing law. False statements. The principal federal statute criminalizing false statements to government investigators is 18 U.S. Code, Section 1001. As relevant here, under Section 1001A2, it is a crime to knowingly and willfully make any materially false, fictitious, or fraudulent statement or representation in any matter within the jurisdiction of the executive branch of the government. An FBI investigation is a matter within the executive branch's jurisdiction. The statute also applies to a subset of legislative branch actions, namely administrative matters and investigations or reviews conducted by a congressional committee or subcommittee. Whether the statement was made to law enforcement or congressional investigators, the government must prove beyond a reasonable doubt the same basic non-jurisdictional elements. The statement was false, fictitious, or fraudulent. The defendant knew both that it was false and that it was unlawful to make a false statement, and the false statement was material. In the D.C. Circuit, the government must prove that the statement was actually false. A statement that is misleading but literally true does not satisfy Section 1001A2. For that false statement to qualify as material, it must have a natural tendency to influence or be capable of influencing a discrete decision or any other function of the agency to which it is addressed. Perjury. Under the federal perjury statutes, it is a crime for a witness testifying under oath before a grand jury to knowingly make any false material declaration. The government must prove 4 elements beyond a reasonable doubt to obtain a conviction under Section 1623A. The defendant testified under oath before a federal grand jury. The defendant's testimony was false in one or more respects. The false testimony concerned matters that were material to the grand jury investigation, and the false testimony was knowingly given. The general perjury statute, 18 U.S. Code, Section 1621, also applies to grand jury testimony and has similar elements, except that it requires the witness to have acted willfully and that the government satisfy strict common law requirements for establishing falsity. Obstruction of justice. 3 basic elements are common to the obstruction statutes pertinent to this office's charging decisions: an obstructive act, some form of nexus between the obstructive act and an official proceeding, and criminal, i.e. corrupt, intent. A detailed discussion of those elements, and the law governing obstruction of justice more generally, is included in Volume 2 of the report. B. Application to certain individuals. 1. George Papadopoulos. Investigators approached Papadopoulos for an interview based on his role as a foreign policy advisor to the Trump campaign, and his suggestion to a foreign government representative that Russia had indicated that it could assist the campaign through the anonymous release of information damaging to candidate Clinton. On January 27, 2017, Papadopoulos agreed to be interviewed by FBI agents, who informed him that the interview was part of the investigation into potential Russian government interference in the 2016 presidential election. During the interview, Papadopoulos lied about the timing, extent, and nature of his communications with Joseph Mifsud, Olga Polinskaya, and Ivan Timofeev. With respect to timing, Papadopoulos acknowledged that he had met Mifsud and that Mifsud told him that the Russians had dirt on Clinton in the form of thousands of emails. But Papadopoulos stated multiple times that those communications occurred before he joined the Trump campaign, and that it was a very strange coincidence to be told of the dirt before he started working for the campaign. This account was false. Papadopoulos met Mifsud for the first time on approximately March 14, 2016, after Papadopoulos had already learned he would be a foreign policy advisor for the campaign. Mifsud showed interest in Papadopoulos only after learning of his role on the campaign, and Mifsud told Papadopoulos about the Russians possessing dirt on candidate Clinton in late April 2016, more than a month after Papadopoulos had joined the campaign and been publicly announced by candidate Trump. Papadopoulos also made false statements in an effort to minimize the extent and importance of his communications with Mifsud. For example, Papadopoulos stated that Mifsud's a nothing, that he thought Mifsud was just a guy talking up connections or something, and that he believed Mifsud was BSing, to be completely honest with you. In fact, however, Papadopoulos understood Mifsud to have substantial connections to high-level Russian government officials, and that Mifsud spoke with some of those officials in Moscow before telling Papadopoulos about the dirt. Papadopoulos also engaged in extensive communications over a period of months with Mifsud about foreign policy issues for the campaign, including efforts to arrange a history-making meeting between the campaign and Russian government officials. In addition, Papadopoulos failed to inform investigators that Mifsud had introduced him to Timofeev, the Russian national who Papadopoulos understood to be connected to the Russian Ministry of Foreign Affairs, despite being asked if he had met with Russian nationals or anyone with a Russian accent during the campaign. Papadopoulos also falsely claimed that he met Polinskaya before he joined the campaign, and falsely told the FBI that he had no relationship at all with her. He stated that the extent of their communications was her sending emails. Just, "Hi, how are you?" That's it. In truth, however, Papadopoulos met Polinskaya on March 24, 2016, after he had joined the campaign. He believed that she had connections to high-level Russian government officials and could help him arrange a potential foreign policy trip to Russia. During the campaign, he emailed and spoke with her over Skype on numerous occasions about the potential foreign policy trip to Russia. Papadopoulos' false statements in January 2017 impeded the FBI's investigation into Russian interference in the 2016 presidential election. Most immediately, those statements hindered investigators' ability to effectively question Mifsud when he was interviewed in the lobby of a Washington, D.C. hotel on February 10, 2017. During that interview, Mifsud admitted to knowing Papadopoulos and to having introduced him to Polinskaya and Timofeev. but Mifsud denied that he had advanced knowledge that Russia was in possession of emails damaging to candidate Clinton, stating that he and Papadopoulos had discussed cybersecurity and hacking as a larger issue, and that Papadopoulos must have misunderstood their conversation. Mifsud also falsely stated that he had not seen Papadopoulos since the meeting at which Mifsud introduced him to Polinskaya, even though emails, text messages, and other information showed that Mifsud met with Papadopoulos on at least 2 other occasions, April 12 and April 26, 2016. In addition, Mifsud omitted that he had drafted or edited the follow-up message that Polinskaya sent to Papadopoulos following the initial meeting, and that, as reflected in the language of that email chain, "Baby, thank you," Mifsud may have been involved in a personal relationship with Polinskaya at the time. The false information and omissions in Papadopoulos' January 2017 interview undermined investigators' ability to challenge Mifsud when he made these inaccurate statements. Given the seriousness of the lies and omissions, and their effect on the FBI's investigation, the office charged Papadopoulos with making false statements to the FBI in violation of 18 U.S. Code Section 1001. On October 7, 2017, Papadopoulos pleaded guilty to that charge pursuant to a plea agreement. On September 7, 2018, he was sentenced to 14 days of imprisonment, a $9,500 fine, and 200 hours of community service. 2. Short redaction citing personal privacy. 2 paragraphs, approximately 13 to 14 lines, redacted citing grand jury and personal privacy. 3. Michael Flynn. Michael Flynn agreed to be interviewed by the FBI on January 24, 2017, 4 days after he had officially assumed his duties as National Security Advisor to the President. During the interview, Flynn made several false statements pertaining to his communications with the Russian ambassador. First, Flynn made 2 false statements about his conversations with Russian Ambassador Kislyak in late December 2016, at a time when the United States had imposed sanctions on Russia for interfering with the 2016 presidential election, and Russia was considering its response. Flynn told the agents that he did not ask Kislyak to refrain from escalating the situation in response to the United States' imposition of sanctions. That statement was false. On December 29, 2016, Flynn called Kislyak to request Russian restraint. Flynn made the call immediately after speaking to senior transition team official, Katie McFarland, about what to communicate to Kislyak. Flynn then spoke with McFarland again after the Kislyak call to report on the substance of that conversation. Flynn also falsely told the FBI that he did not remember a follow-up conversation in which Kislyak stated that Russia had chosen to moderate its response to the U.S. sanctions as a result of Flynn's request. On December 31, 2016, Flynn in fact had such a conversation with Kislyak, and he again spoke with McFarland within hours of the call to relay the substance of his conversation with Kislyak. Second, Flynn made false statements about calls he had previously made to representatives of Russia and other countries regarding a resolution submitted by Egypt to the United Nations Security Council on December 21, 2016. Specifically, Flynn stated that he only asked the countries' positions on how they would vote on the resolution, and that he did not request that any of the countries take any particular action on the resolution. That statement was false. On December 22, 2016, Flynn called Kislyak, informed him of the incoming Trump administration's opposition to the resolution, and requested that Russia vote against or delay the resolution. Flynn also falsely stated that Kislyak never described Russia's response to his December 22 request regarding the resolution. Kislyak, in fact, told Flynn in a conversation on December 23, 2016, that Russia would not vote against the resolution if it came to a vote. Flynn made these false statements to the FBI at a time when he was serving as National Security Advisor, and when the FBI had an open investigation into Russian interference in the 2016 presidential election, including the nature of any links between the Trump campaign and Russia. Flynn's false statements and omissions impeded and otherwise had a material impact on that ongoing investigation. They also came shortly before Flynn made separate submissions to the Department of Justice, pursuant to FARA, that also contained materially false statements and omissions. Based on the totality of that conduct, the office decided to charge Flynn with making false statements to the FBI in violation of 18 U.S. Code, Section 1001A. On December 1, 2017, and pursuant to a plea agreement, Flynn pleaded guilty to that charge and also admitted his false statements to the department in his FARA filing. Flynn is awaiting sentencing. 4. Michael Cohen. Michael Cohen was the executive vice president and special counsel to the Trump Organization when Trump was president of the Trump Organization. From the fall of 2015 through approximately June 2016, Cohen was involved in a project to build a Trump-branded tower and adjoining development in Moscow. The project was known as Trump Tower Moscow. In 2017, Cohen was called to testify before the House Permanent Select Committee on Intelligence, HPSCI, and the Senate Select Committee on Intelligence, SSCI, both of which were investigating Russian interference in the 2016 presidential election and possible links between Russia and the presidential campaigns. In late August 2017, in advance of his testimony, Cohen caused a 2-page statement to be sent to SSCI and HPSCI addressing Trump Tower Moscow. The letter contained 3 representations relevant here. First, Cohen stated that the Trump Moscow project had ended in January 2016, and that he had briefed candidate Trump on the project only 3 times before making the unilateral decision to terminate it. Second, Cohen represented that he never agreed to travel to Russia in connection with the project and never considered asking Trump to travel for the project. Third, Cohen stated that he did not recall any Russian government contact about the project, including any response to an email that he had sent to a Russian government email account. Cohen later asked that his 2-page statement be incorporated into his testimony's transcript before SSCI, and he ultimately gave testimony to SSCI that was consistent with that statement. Each of the foregoing representations in Cohen's 2-page statement was false and misleading. Consideration of the project had extended through approximately June 2016 and included more than 3 progress reports from Cohen to Trump. Cohen had discussed with Felix Sater his own travel to Russia as part of the project, and he had inquired about the possibility of Trump traveling there, both with the candidate himself and with senior campaign official Corey Lewandowski. Cohen did recall that he had received a response to the email that he sent to Russian government spokesman Dmitry Peskov. In particular, that he received an email reply and had a follow-up phone conversation with an English-speaking assistant to Peskov in mid-January 2016. Cohen knew the statements in the letter to be false at the time and admitted that he made them in an effort, 1, to minimize the links between the project and Trump, who by this time was president, and 2, to give the false impression that the project had ended before the first vote in the Republican Party primary process, in the hopes of limiting the ongoing Russia investigations. Given the nature of the false statements and the fact that he repeated them during his initial interview with the office, we charged Cohen with violating Section 1001. On November 29, 2018, Cohen pleaded guilty pursuant to a plea agreement to a single-count information charging him with making false statements in a matter within the jurisdiction of the legislative branch in violation of 18 U.S. Code, Section 1001, A2 and C. The case was transferred to the district judge presiding over the separate prosecution of Cohen, pursued by the Southern District of New York, after a referral from our office. On December 7, 2018, this office submitted a letter to that judge recommending that Cohen's cooperation with our investigation be taken into account in sentencing Cohen on both the false statements charge and the offenses in the Southern District prosecution. On December 12, 2018, the judge sentenced Cohen to 2 months of imprisonment on the false statements count, to run concurrently with a 36-month sentence imposed on the other counts. 5. Roger Stone. As explained more fully in Volume 1, Section 3D1 Supra, Roger Stone is a longtime Trump associate, worked for the Trump campaign briefly in 2015, and remained in contact with senior campaign officials through the campaign period. By no later than the summer of 2016, Stone communicated with the campaign about upcoming WikiLeaks releases of hacked materials that were expected to harm Hillary Clinton's candidacy. Stone sent author Jerome Corsi messages urging him to get to Assange at the Ecuadorian embassy in London, and received back correspondence from Corsi passing along word that friend and embassy plans 2 more dumps in the summer and fall. Stone spoke publicly about access to Assange, and after radio host Randy Credico interviewed Assange, Stone asked Credico to contact and obtain information from Assange, and in early October 2016, Stone assured individuals involved in the campaign that a WikiLeaks release was imminent. When asked to appear before HPSCI and provide documents, Stone caused a letter to be submitted to HPSCI in May 2017, stating that he had no relevant records. During his testimony before HPSCI in September 2017, Stone testified in pertinent part that he did not have emails with third parties about Assange or any documents referring to Assange, that his references in August 2016 to being in contact with Assange had been references to communications with a single intermediary, whom Stone later identified as Credico. That Stone did not ask this intermediary to communicate anything to Assange or to do anything on Stone's behalf. That the intermediary did not communicate via text message or email about WikiLeaks with Stone, and that Stone had never discussed his conversations with the intermediary with anyone in the Trump campaign. Each of these statements was false. Stone had in his custody or control email communications with Corsi and Credico about Assange and WikiLeaks. Stone's August 2016 public statements about access to Assange were not solely about communications through Credico, who had not yet interviewed or met Assange at the time. Stone had asked Credico to pass along a message to Assange and find out information from him. Stone and Credico had communicated extensively over text message about WikiLeaks, and Stone had discussed his contacts to Assange and an imminent WikiLeaks release with the Trump campaign, including in the days leading to the October 7, 2016 release of the Podesta emails. After falsely telling Congress that Credico was his lone intermediary or go-between, Stone repeatedly contacted Credico in an effort to prevent Credico from contradicting Stone's statements to HPSCI. Between November and December 17, 2017, Stone texted Credico, urging him to stonewall and plead the Fifth, and stating that he should do a Frank Pentangeli before HPSCI, a reference to a character in The Godfather Part 2 who testified before a congressional committee and claimed not to know information incriminating a mafia figure in perjury before the same committee. In 2018, after Credico advised HPSCI that he would invoke his Fifth Amendment rights, Stone continued to contact Credico, calling him a rat and stating that he would take that dog, a reference to Credico's support dog, away from him. Based on the foregoing conduct, on January 24, 2019, a grand jury in the District of Columbia returned a 7-count indictment charging Stone with 1 count of obstructing and endeavoring to obstruct a congressional proceeding in violation of 18 U.S. Code, Section 1505, 5 counts of making false statements to Congress in violation of 18 U.S. Code, Section 1001A and C, and 1 count of witness tampering in violation of 18 U.S. Code, Section 1512B1. Stone has entered a plea of not guilty to all charges and is currently pending trial. 6. Jeff Sessions. As set forth in Volume 1, Section 4A6 Supra, the investigation established that, while a U.S. Senator and a Trump campaign advisor, former Attorney General Jeff Sessions interacted with Russian Ambassador Kislyak during the week of the Republican National Convention in July 2016, and again at a meeting in Sessions' Senate office in September 2016. The investigation also established that Sessions and Kislyak both attended a reception held before candidate Trump's foreign policy speech at the Mayflower Hotel in Washington, D.C. in April 2016, and that it is possible that they met briefly at that reception. The office considered whether, in light of these interactions, Sessions committed perjury before or made false statements to Congress in connection with his confirmation as Attorney General. In January 2017 testimony during his confirmation hearing, Sessions stated in response to a question about Trump campaign communications with the Russian government that he had been called a surrogate at a time or two in that campaign, and I didn't have, re-emphasizing, did not have, communications with the Russians. In written responses submitted on January 17, 2017, Sessions answered no to a question asking whether he had been in contact with anyone connected to any part of the Russian government about the 2016 election, either before or after Election Day. And in a March 2017 supplement to his testimony, Sessions identified 2 of the campaign period contacts with Ambassador Kislyak noted above, which had been reported in the media following the January 2017 confirmation hearing. Sessions stated in the supplemental response that he did not recall any discussions with the Russian ambassador or any other representatives of the Russian government regarding the political campaign on these occasions or any other occasion. Although the investigation established that Sessions interacted with Kislyak on the occasions described above, and that Kislyak mentioned the presidential campaign on at least one occasion, the evidence is not sufficient to prove that Sessions gave knowingly false answers to Russia-related questions in light of the wording and context of those questions. With respect to Sessions' statements that he did not recall any discussions with the Russian ambassador regarding the political campaign, and he had not been in contact with any Russian official about the 2016 election, the evidence concerning the nature of Sessions' interactions with Kislyak makes it plausible, that Sessions did not recall discussing the campaign with Kislyak at the time of his statements. Similarly, while Sessions stated in his January 2017 oral testimony that he did not have communications with Russians, he did so in response to a question that had linked such communications to an alleged continuing exchange of information between the Trump campaign and Russian government intermediaries. Sessions later explained to the Senate and to the office that he understood the question as narrowly calling for disclosure of interactions with Russians that involved the exchange of campaign information as distinguished from more routine contacts with Russian nationals. Given the context in which the question was asked, that understanding is plausible. Accordingly, the office concluded that the evidence was insufficient to prove that Sessions was willfully untruthful in his answers, and thus insufficient to obtain or sustain a conviction for perjury or false statements. Consistent with the principles of federal prosecution, the office therefore determined not to pursue charges against Sessions, and informed his counsel of that decision in March 2018. 7. Others interviewed during the investigation. The office considered whether during the course of the investigation, other individuals interviewed either omitted material information or provided information determined to be false. Applying the principles of federal prosecution, the office did not seek criminal charges against any individuals other than those listed above. In some instances, that decision was due to evidentiary hurdles to proving falsity. In others, the office determined that the witness ultimately provided truthful information and that considerations of culpability, deterrence, and resource prevention weighed against prosecution. Below, we describe briefly our decisions as to 3 of those individuals. About half a line redacted, citing personal privacy. We also considered 3 other individuals interviewed, half a line redacted, citing personal privacy, but do not address them here because they are involved in aspects of ongoing investigations or active prosecutions to which their statements to this office may be relevant. Short redaction, citing personal privacy. When initially interviewed by the office regarding short redaction, citing personal privacy, roll in, short redaction, citing personal privacy, and other matters, short redaction, citing personal privacy, provided information that appeared to be false in several respects. About 3 lines redacted, citing personal privacy, and grand jury. Also faces criminal charges in a sealed criminal complaint in the Eastern District of Virginia, based on criminal conduct separately referred by this office. The referred conduct does not relate to Russia, the 2016 election, or the Trump campaign. For all of these reasons, the office determined not to charge short redaction citing personal privacy. Short redaction citing personal privacy. 4 lines redacted, citing personal privacy and grand jury. Ultimately, however, the office did not have sufficient evidence to prove beyond a reasonable doubt that either strand of testimony constituted an intentional falsehood that violated 18 U.S. Code, Section 1001. Short redaction citing personal privacy. The office interviewed half a line redacted, citing personal privacy, 3 times, 1 line redacted, citing personal privacy. Those interviews addressed, in pertinent part, short redaction citing personal privacy, communications with, about 1 line redacted, citing personal privacy, was interviewed again, half a line redacted, citing personal privacy. Statements in that final interview showed that, short redaction citing personal privacy, earlier statements to the FBI were at a minimum incomplete. The office concluded that it did not have sufficient evidence to prove beyond a reasonable doubt that short redaction citing personal privacy had intentionally made false statements during short redaction citing personal privacy earlier interviews. Thank you for listening to this episode. This show operates on the value for value model. I make the show available, commercial-free, and you decide what it's worth. You can return the value in any way you choose. One way is by going to MuellerReportAudio.com and clicking on the Donate button, or supporting with a recurring monthly donation at patreon.com/TimberlaneMedia. For your donation, and to show my appreciation, I will recognize your name and donation amount in an upcoming episode. Or you can remain anonymous by going to glow.fm/insider. You can also value these episodes by sharing the show and telling your friends. Or you can follow on Twitter @GovUnfiltered or at facebook.com/governmentunfiltered. Thank you for helping make public documents like this one accessible through audio.